risks encouraging it. So we ask, who are these actors who are delaying and prevaricating and providing inadequate responses? And allow us, please, to see that process in real time. Thirdly, my lady, applying even the greatest optimism, of course, all of us in this room must do that. Experience dictates that the inquiry's aim of largely completing disclosure by the end of July is likely, in fact, highly likely, not to be met. Putting to one side the issue of WhatsApp and Google Spaces and the magnitude of data and information that will come, we hope, and come soon from that source, we only have to look at the response from the Department of Health and Social Care to appreciate where the delays will fall. I preface my submissions, my lady, with the observation that undoubtedly a significant burden has been placed on that particular department, and that the demands of the inquiry are undoubtedly resource intensive. But my lady, corporate statements that were requested in September 2022, 9 months later, are yet to be delivered. 9 months. We are told in the submissions that the first statement might be with the inquiry this week, together with exhibits totalling 890. We are told we can expect its sister statement, hopefully, towards the end of the month, together with another 400 or so exhibits. A total of almost 1,300 exhibits under cover of 2 statements that have taken over 9 months to put together will be given to the inquiry in the coming weeks at a time when Module 1 has already commenced, when attention is diverted to a judicial review application, and we are hurtling towards the start date of Module 2. It affords precious little time for this inquiry to consider them for onward disclosure to core participants, undoubtedly meaning, with the best will in the world and working round the clock within your team, that we will have them for a few comparatively short weeks before the hearings commence. My lady, we mean no criticism of you or your team when we observe that that is simply, from our perspective, not good enough. The Northern Irish COVID bereaved Families for Justice, as we are doing in Module 1, will find ourselves without enough hours in the day to properly prepare for the full hearing if we don't get this material sooner than the time frame which these departments are allocating to themselves. Fourthly, my lady, I note today, and perhaps I can take this rather shortly, I was going to observe on the difficulty in identifying really where Northern Ireland fits within this module. We have previously made suggestions on Rule 9 recipients, and we have not had any clarity on the extent to which those have been accepted or actioned. But I note that there is to be, within the coming days, a full list of Rule 9 recipients, and we look forward to receipt of that. And we will work together with your team in relation to it. We have had precious little Northern Irish related disclosure. The Cabinet Office had not yet managed to identify disclosure relevant to Whitehall's communication with the devolved administration in the early days of the pandemic, and indeed beyond. That came as some surprise, but we hope it has been resolved. But if I may, we would ask that in addition to those requests being made of Whitehall, particularly given the very recent history in relation to disclosure, we would ask that the mirrored requests are made of Cardiff, Edinburgh and Belfast, so that we can scrutinise the disclosure by way of a complete picture. The combination of these issues, my lady, really reinforces the request that we have been making for some time. Some might say the drum that we have been beating. Primary concern is that disclosure is coming too late for adequate consideration. A predictable effect of individuals and government departments running down the clock with internal searches and delays and prevarication is the inevitable reduction of time and resources available for public scrutiny at the other end, and that is increasingly of concern. My lady, we reiterate our request, and it will come as no surprise to have sight of if not input into the Rule 9 requests. The revelations on Twitter reinforce that, if I may say so. Having sight of those Rule 9 requests would be, firstly, instrumental in ensuring the family's continued confidence in this process. But secondly, they are also likely to be the yardstick by which the answers that come in response to them are measured. And so we do invite you to reconsider disclosure of those requests so that we can compare and contrast the answers that come. As has already been observed by Ms. Mirage, it is important, and we know My Lady will hear from bereaved family members as part of Module 2. Module 2, we submit, will be significantly the poorer if it does not hear and listen to those most directly affected. And it's a submission that is echoed by many of the core participants in the room today. A significant measure of the adequacy of government response is the impact that it had on those most directly affected. We note what Mr. Keith has said today by way of update and observations. Any submissions or suggestions that we make going forward in relation to those from whom you should hear will bear in mind at all stages the need to assist the inquiry's work in this module and on the issues under consideration. But our clients have a great deal to say, and although their experiences and perspectives have been informed by the magnitude of their individual loss, it is not limited to that. And so we urge you to take a generous approach to the time allocated to hearing from the bereaved and indeed from other core participants in civil society in this module. My Lady, I need say nothing about the issue of Cabinet collective responsibility given the update. And we have referred in our written submission to our view of the announcement in relation to panellists. We rely largely on those submissions, but we also join forces with the voices from the Cymru group in observing that the opportunity for you to be assisted by panel members, and particularly those with a detailed knowledge of the devolved administrations, appears to have been missed in our submission by the Prime Minister, but it is not too late. And we would strongly urge the Prime Minister, through you, to reflect on that latest decision, to recognise the value that diverse and experienced panel members could bring to this process. And given what we know to be the problem or the source of delays, it is, we submit, unfortunate for the Prime Minister to rely on perceived criticism around delays as a reason to deny the fullest possible scrutiny. In relation to the list of issues, My Lady, we endorse and adopt the submissions that you have heard. We had made submissions, specific observations in relation to the interface between this module and Module 2C from a Northern Irish perspective. But we see the sense in Mr. Keith's submission this morning that that interface is perhaps best ironed out when the list of issues in relation to Module 2C is closer to its final form. Our work in relation to responding to the Module 2C list of issues is proceeding apace so that we can respond fully within the deadline, which I think is next week. My Lady, dealing then just briefly with expert witnesses before concluding on every story matters in the tapestry. We have been firm supporters of the inquiry's decision to approach expert witnesses, and we continue to be. We are grateful to Professor Hale and Professor Henderson for the care and detail in their report. The clarity of their report undoubtedly belies the great effort and skill that went into drafting them. But they are inevitably UK focused, and although there is a nod, and in some cases that is an underestimate, more than a nod towards Northern Ireland, we submit that more can be gained from their expertise. And it's really in that vein that we have provided detailed responses which are intended to be constructive, and we would ask that both the entire inquiry team and indeed the experts view them in that manner. However, our responses are hampered in two regards. Firstly, because of this habit of not giving us the references upon which they rely, and we're grateful that that observation has been taken forward with the experts. But secondly, by the ongoing non-disclosure of witness statements from government departments and ministers and indeed others. And one Practical consequences of that, we submit, is that it may well be, on receipt of further statements, that the experts do need to be asked to consider and comment further. Yet another piece of work for those involved in this inquiry, occasioned by the delay. In relation to Every Story Matters and the tapestry, our concerns have found their voice in those of Miss Mirage. I think it can be summarised in this way, that at present the Northern Irish bereaved do not see their experience of grief or loss or trauma reflected in that tapestry artwork, nor for the moment in the outworking of the Every Story Matters. But we will persist in communicating with your team and those responsible to see how those issues can be resolved. Our clients remain very actively engaged, and my lady very willing to assist you in understanding their concerns, but also reaching the conclusions that this inquiry really needs to reach sooner rather than later. Thank you.
Thank you very much, Ms Campbell. In relation to that last point, I mean, I know that when you make offers of help, you mean it on behalf of those whom you represent. And going back to the impact film to which I referred earlier when speaking to Ms Mirage, the first impact film that's been produced, and I do hope people will be able to feel they can watch it, because it is extraordinarily moving. And we'll have to have a number of warnings before it is shown. But it shows a diverse group of bereaved people speaking about their loss in most extraordinarily moving terms. And as I said to Ms Mirage, introducing items that I hadn't realised I should be investigating. So it's not only very moving, but also very helpful. And two of the most insightful participants do come from Northern Ireland on that film. So I am extremely grateful for the help that they've given. And I hope it does continue. And we're always prepared to listen. So I hope that message has got across. As far as the disclosure of the Rule 9 request, as you may know, that was not the inquiry team that put the Rule 9 request on Twitter. I think Mr Keith may or may not be able to help us to who it was, but it wasn't us. And the last point really is in relation to timing. I do understand the points, very valid points you make about timing and the demands on everybody, the inquiry team, but also core participants. All I can say is that everyone needs to know that, as far as I'm concerned, these hearings for Module 2 will start in October. And so I'm afraid everybody, material providers, legal representatives, they're all going to have to work very hard, I'm afraid, but that's my present position. So thank you very much for your submissions. Right, Ms Mitchell. Oh, there you are. I did say the layout of this venue wasn't perfect, but are you by a microphone? Quite
red. Oh, it's gone green. Thank you. Milady, we've taken careful consideration of what's been said this morning and hope to restrict our submissions to less than 15 minutes. I'm obliged to the comments of the Chair and also Senior Counsel to the inquiry. There are 7 discrete issues that I'd like to raise. The first simply is comment in relation to panellists. We note that a decision has only recently been taken that the Chair will sit without a panel. It's disappointing that a decision has been taken so late and in such proximity to the hearings, under explanation that the Prime Minister was conscious of not wishing to delay the production of a report from this inquiry. This desire doesn't seem to be a consistent approach of government in dealing with requests from the inquiry, particularly, as we've heard this morning, in relation to Rule 9s. The second issue is that of Rule 9 requests. The Scottish COVID bereaved are obliged to counsel to the inquiry and the inquiry legal team for providing the update that they have. It will come, of course, as no surprise to Milady that the Scottish COVID bereaved are concerned to understand that this process is not being carried out as it should by all government departments. As it ought to have been clear to those organising as ought to have been clear to those organisations. Supplying insufficient detail suggests a lack of cooperation with the work of the inquiry at the most fundamental level of the provision of specific information. The Scottish Covid bereaved are grateful in respect of the transparent way in which counsel to the inquiry and the chair is dealing with this matter, and anticipate that those in receipt of Rule 9 letters, which have been responded to in a less than satisfactory way, will now understand that they properly require to do so. The inquiry this morning and senior counsel to the inquiry has mentioned the fact that repeated deadlines have passed and extensions have been required. It doesn't need me to highlight to the chair that if repeated deadlines are allowed to pass with impunity, a deadline becomes no more than a suggestion by which date documents should be provided. The way in which these Rule 9 responses have been dealt with does not provide the Scottish Code bereaved with confidence that, where appropriate, the same parties understand and are properly implementing their disclosure duties. We would ask this morning that the Chair, in the event of further time limits not being obtempered, gives consideration to what practical steps she can take in order to highlight to those who are not responding timelessly to requests that this matter will not be tolerated by this inquiry. Number 3, the redaction of material and WhatsApp messages. We note, of course, what has already been said by the Chair and Senior Counsel to the inquiry, that these matters will shortly be addressed elsewhere. Briefly, the Scottish Covid bereaved wish to make some observations which we hope will be heard and considered primarily by the Cabinet Office, given we understand the view of the Chair and Counsel to the inquiry already. Again, it won't come as a surprise to the inquiry that the view of the Scottish Covid bereaved is that whatever is supplied, retracted or otherwise, the process of consideration and retraction will have to be carried out by the inquiry. Given the very short timescales left, caused by the unnecessary delay in the Cabinet Office, it is submitted that this in and of itself should be sufficient for the Cabinet Office to consider that matters should be passed unredacted to this inquiry. If it carries out that redaction process first and then gives it to this inquiry, it means that the job has to be done twice. At a most practical level, this will no doubt possibly potentially delay this project further. We would respectfully submit that sending to this public inquiry unredacted copies of everything would be consistent with the Prime Minister's view that decisions should be taken with a mind to not delaying the production of a report by this inquiry, and we would commend this as a way forward to the Cabinet Office. The second issue of concern is that the Cabinet Office considers it is in a place to consider what is relevant to this inquiry, for only then could it be assured that it is redacting things that it considers are irrelevant. The Scottish Covid bereaved do not share the confidence of the Cabinet Office in this task. This inquiry needs to obtain and provide to core participants documents that provide a transparent insight into the working of government during a lengthy period of national crisis. From what families of those who died during COVID have heard so far from those who have made the decisions, it does not inspire any confidence that by obtaining only formal documents, this will suffice for us to be able to build a picture of what was happening. Matters which may not strike the Cabinet Office as relevant may be highly relevant in context. The inquiry is, of course, best pleased to have the best insight into what is and is not relevant. And that is why Parliament has enacted a statutory scheme which places the inquiry as the heart of deciding what is and is not relevant. Finally, what is being sought is written records recording the work of public servants involved in taking decisions which affected millions of people in the UK. This inquiry has repeatedly stated it will be robust, and its actions to date support that claim. A robust approach in the present circumstances is the ingathering of potentially relevant information in an unredacted form and allowing this inquiry, the body best pleased to do so, to carry out its job. If parts of the documents are clearly irrelevant, they can be redacted by the inquiry. Only then can there be confidence that the job is being done in the application of the proper test for the disclosure and that it has been done in a transparent way. There can be no good reason for failing to provide the documents requested to the inquiry in an unredacted form, save for a pathological need to protect information for its own sake, rather than there being anything intrinsic to the information that requires to be kept secret. The government is, or at least should be, answerable to the people. The public, through this inquiry, are entitled to know what decisions were taken, by whom and when. Moving briefly on to the issue of WhatsApp messages in particular. In relation to WhatsApp messages and informal methods of communication, we note that a request has been made for over 30 Cabinet witnesses to provide relevant information, and that only 3 have complied, including Mr Johnston, and even then there have been redactions. The Scottish Covid bereaved remind the inquiry of the media reporting of Mr Hancock's book, where it is said, "We now chew over big decisions elsewhere and relegate formal meetings to rubber stamping exercises." It's therefore vital to understand where and when, using these, for example, informal methods of communication, where these big decisions were being taken. And that's why it's vital that this information is captured and presented to the inquiry in an unredacted format to allow this to happen. At the preliminary hearing on the 1st March, we stated that anything less than full disclosure would be considered as an attack on the integrity of both the UK and the Scottish public inquiries by the Scottish Covid bereaved. We said that no individual, no matter how powerful, can be allowed to interfere with the pursuit of truth, justice and accountability in this inquiry. Those who lost their lives to Covid-19 deserve nothing less. At the time, Hugo KC explained to the inquiry that each witness to the inquiry had been asked to disclose emails and other correspondence relevant to the issues addressed in their proposed witness statements and informal or private communications about the government's response to the Covid-19 pandemic to which they were party. He added that the documents include, but weren't limited to, WhatsApp group messages, private messages, email communications, contemporary diary or other notes, and explained that he had cast the net widely and with a fine mesh. In relation to Scotland, we have been advised by the Scottish Ministers' Council that the former First Minister Nicola Sturgeon was asked for such informal message, but she has none. Ms Sturgeon is of course due to give evidence along with the former Deputy First Minister John Swinney, Catherine Calderwood and former Health Minister Jean Freeman in Module 1 in 3 weeks' time. The inquiry will know that there will be overlap between witnesses to this inquiry and witnesses to the Scottish inquiry. A request has also been made in the same terms by the lead solicitor Amar Anwar for the Scottish Covid inquiry in relation to WhatsApp messages. On the 4th of June on BBC Scotland, a former Health Minister, Jean Freeman, appeared in the programme and was asked for all WhatsApp messages and other materials to be released. She stated, "Nobody's asked for these WhatsApp yet from the Scottish inquiry, so therefore nobody's refused." We note that Ms Freeman limited her comments to the Scottish inquiry, but in light of all the foregoing, the Scottish Covid bereaved have a number of questions. As previously stated, it's for the inquiry chair to determine what is relevant or potentially relevant. We understand that if a witness says, "I have some things of relevance," then the position of this inquiry is that the information should be provided in whole in order for them to establish what is relevant and what is not relevant. What we ask, though, is where a witness says, "I have nothing of relevance," in relation to a request for informal communications, is that an end to the matter? Is this primary consideration of all communications the start and the end of that process? Because the Scottish Covid bereaved would submit that the inquiry should determine whether or not there is anything relevant to the inquiry and not the person from whom the informal communication method is requested. Given the fact that we are told that formal meetings were rubber-stamped, it may be, for example, vitally important about the organisation or the timing of a meeting, which would not perhaps strike anyone as immediately relevant to the inquiry, but in fact could absolutely be so. It's submitted that despite the clear way in which this has been asked for, it may not be clear to witnesses that if any communication is made by a witness which relates to their involvement in COVID, the data should all be made available for the inquiry to carry out this process. Can we be certain that the witnesses are carrying out this primary test correctly? Further, apart from Ms Sturgeon, we are not aware if any of the other Scottish witnesses relevant to this module have considered whether any type of this information ought to have been provided to the UK inquiry. We would submit that Ms Sturgeon and any other Scottish minister should be in no different a position to that of Mr Johnston, Rishi Sunak or Matt Hancock, and that, if not already done, a request should be made of the Scottish ministers to provide to the inquiry any communications held by informal means in order that the primary relevance test can be carried out by this inquiry. My lady, I only have a short number of comments still to make, but I note the time. Would my lady prefer me?
I've just been told, Ms Mitchell, that Ms Heaven, who's speaking for Bereaved Families for Justice Cymru, can't be here this afternoon. So if everyone forgive me, and if their tummies aren't rubbling too much, I would go on and complete your submissions and Ms Heaven's.
I'm obliged, and I will take it short, my lady.
Thank you.
In relation to Cabinet collective responsibility, we note the Cabinet Office may no longer wish to rely on this principle, and we look forward to hearing from Mr Chapman in this regard. We would ask, rather than me reiterating it here, we would ask that the Cabinet Office read the written submissions provided in this regard to understand the position of the Scottish COVID bereaved. As will be unsurprising, it is that the Scottish COVID bereaved are put short of the view that there's no principle which in the modern day should prevent proper scrutiny being brought to bear on the decision-making process taken by publicly elected servants in circumstances where the lives of millions of people depend on those decisions being properly taken. 5. Disclosure to core participants. We note the progress being made with disclosure for Module 2 and the work being done to provide these as soon as possible. We note the alarming number of 35,000 documents. We simply want to place a flag, my lady, to note that we are concerned that the number of documents which were being disclosed means that there will be little time for core participants to assess these to a meaningful degree up to and before the inquiry is due to begin. We appreciate and of course desire the remarkable pace that matters are taking place, but we have to flag up the possibility in the future that it may be we have to effectively let the inquiry know that questions that we're being asked to or things that we're being asked to contribute to can't be meaningfully contributed to at that time until we have a better grasp on disclosure. We understand that we are having a great deal of input into how matters are done. Provisional list of witnesses, provisional list of issues, proposed evidence proposals, and even questions for witnesses. But all those can only have proper input if we properly understand the disclosure in advance. And I appreciate it will become a chicken and egg problem, but I simply flag up at this stage that we may need to revisit that matter and inform the inquiry that we're not yet in a position to answer timescales which have been set. Number 6, every story matters. We note that Senior Counsel explained that the inquiry does intend to call a range of witnesses from across bereaved groups, and the Scottish COVID bereaved are happy to assist in that regard. We also look forward to seeing the first impact films on the 13th of June. Finally, 7, a practical issue, and this is in respect of all modules. We attended at the familiarisation hearing this morning, and it was explained to us how the transcripts would work, and that we would be able to intromit with those transcripts by way of highlighting, by way of editing, by way of taking annotated notes. That's all well and good until we were told that, however, we can't keep those, and at the end of the day, those disappear. which unfortunately in a practical sense simply defies the point of the process, because it means that there is no way of us being able to record that. We would ask that the inquiry look into software which would allow participants to save the annotated transcripts in order to avoid duplication of work, so as not to provide added expense to the public purse if that work has to be duplicated after hours of the inquiry. These are the submissions for the Scottish COVID bereaved, unless there's anything further, my lady.
No, thank you very much indeed, Ms Mitchell. As ever, you make some important points. And the last one, I had no idea. I'll see whether anything can be done. If it can be done, we'll do it, but I'm not sure. I'll have to check. And can I also thank those whom you represent for their participation in the first Impact film? There should be a series of films. Because, as I said earlier, it was extraordinarily moving, and I know that Scottish Bereaved took part in it, so thank you very much indeed.
I'm obliged.
Right, Miss Heaven, where are you? Oh, over there.
Thank you, my lady. I only intend to make very brief submissions, and you'll be glad to hear that I'll finish well before the lunch break, and thank you for hearing me now. My lady, as you know, I represent the Covid-19 bereaved families for Justice Cymru. Many of those whom I represent are not able to be here today, but they are, as you will be aware, are watching and listening intently. My lady, can I first address the recent decision of the Prime Minister that you will not be sitting with a panel? We understand that the Prime Minister is apparently concerned about the length of time this public inquiry will take to reach its conclusions. My lady, we know from being involved in Module 1 that this inquiry is working at breakneck speed. My lady, we know that you are determined to avoid unnecessary delays because you have recognised the importance of learning lessons as soon as possible, and those whom I represent fully support this approach. My lady, a thorough, rigorous and properly informed public inquiry should not be placed at risk out of a concern for public criticism about delay. My lady, we of course do not question your thoroughness in these proceedings to date. However, we do consider that a panel is going to be essential in later stages of this inquiry, particularly when considering the instruction of further experts. It should not lead to delay if appropriately managed. Indeed, it should speed things up. The reason we raise this issue now of a panel is to ensure that there's a proper understanding of devolution and the impact of COVID-19 in the devolved nations. As you know, Wales, unlike Scotland, does not have its own public inquiry. And as you know, in Module 1, we have expressed some concerns that many of the draft expert reports are largely insufficient in their consideration of the devolved nations. We continue to submit that this inquiry in my lady would be significantly assisted by panel representatives for each devolved nation. Now, of course, this decision, we understand, is not a matter for you, it's a matter for the Prime Minister. We are aware that you consulted with the Prime Minister, or he consulted with you prior to his announcement. So we therefore simply ask that you consider inviting a further discussion of this issue with the Prime Minister, in particular well in advance of the devolved nation specific modules and in the case of Wales. And if that process is to happen, we would value the opportunity to be kept informed so that our members can have an opportunity to further express and develop their views and concerns to the Prime Minister through you in a timely and constructive fashion. Briefly, in respect of Rule 9 matters, I wish to make the following submissions. My lady, you've ruled against the release of Rule 9 requests to call participants, and we note that Mr Keith has raised this matter again today and made clear that your decision remains. However, we do wish to raise this topic once again in light of the deficient and, quite frankly, wholly inadequate witness statements that have been produced by some members of the Welsh Government for Module 1. The vast majority of these witness statements have simply failed to address in sufficient detail key aspects of the pandemic planning and preparation in Wales. Many of these statements do set out the Rule 9 questions that have been asked, and on occasion the inquiry has, unfortunately it appears, not asked sufficiently detailed questions. This has allowed certain very senior ministers in the Welsh Government to simply not address key aspects of their political life when they would or ought to have known about pandemic planning in Wales. This risks there being gaps in the inquiry's knowledge in relation to Wales for Module 1. Now, clearly the inquiry is entitled to assume compliance with the duty of candour, but unfortunately, certainly in the case of Wales and Module 1, some of the inquiry's very broad Rule 9 questions have led to vague answers, often lacking in sufficient detail. In order to avoid further statements having similar flaws in Module 2, and obviously from our perspective in Module 2B, and to save the inquiry chasing witnesses for multiple amended statements, we would ask again that some consideration is given to core participants being able to at least feed into Rule 9 requests or the questions that your inquiry team draft, so that potential topics for inclusion can be raised at the earliest possible opportunity with the inquiry. Milady, as you know, many of those whom I represent were involved in their professional capacities with the Welsh Government, NHS Wales and other institutions associated with the pandemic and the response. And we will be able to use this knowledge to flag to the inquiry certainly discrete relevant areas that ought to be asked in the Rule 9 process. Lady, in respect of disclosure, we make the following short points. We invite the inquiry legal team to clarify the dates by which core participants can expect witness statements and other materials to be disclosed. As you know, in Module 1, many statements have undergone revision, in part due to some of the concerns about lack of detail that I've just mentioned. As a result, in Module 1, core participants with very little time, it's left us with very little time to review material prior to the substantive hearing beginning in a week's time. And certainly in Wales, we're still waiting for key disclosure. In order to avoid a repeat of this situation in Module 2, we simply ask you to clarify as soon as possible whether the deadline that you've provisionally set out of the end of July 2023 for outstanding disclosure is a hard deadline, and that would be for the final versions of statements to be released, and also to inform core participants of the volumes of statements that can be anticipated around this date. My lady, we welcome Mr Keith's indication a moment ago that the inquiry will keep core participants informed of issues of non-compliance with your requests. My lady, we therefore ask the inquiry to clarify whether the concerns around the production of material by a number of government departments in Module 2 includes Welsh governmental bodies. As I've already indicated, we are concerned that in Module 1, the Welsh Government does not appear to have been engaging with the inquiry to a satisfactory degree. If this is the position in relation to Module 2, then we consider that the Welsh public should be told. In respect of the Cabinet Office issue, those whom I represent offer you their full support and clearly endorse the very powerful submissions that have been made today on behalf of the other bereaved family groups. As my lady, you will understand, the devolved administrations will be watching these latest proceedings very closely, because there is no doubt that they will also hold large quantities of WhatsApp and other communications that they will not want to disclose to you. On that point, my lady, can we ask for clarification whether the Welsh Government has also been asked to disclose all WhatsApp messages and related communication and an indication of their response? As with the other bereaved groups, the Covid-19 Bereaved Families for Justice Cymru reiterate the central importance of all bereaved families having confidence in this inquiry. And, my lady, those whom I represent understand that you are taking all the necessary steps to ensure that this remains the case. We note what Mr Keith has said today in respect of applications for a restriction order. In the event that there is an application, we suggest, as we've done in writing, that core participants should be permitted to make written and oral submissions on the procedural approach to be adopted to determine such applications and to grant the right to be heard on the substance of each application. We understand from what's been said today that this is a matter which is to be determined at a later date, subject, of course, to an application being made. In respect of the disclosure of materials relevant to Whitehall's engagement with the devolved administrations, we were deeply concerned to note that such disclosure has been delayed. Mr. Keith touched a moment ago on cross-disclosure between the modules. In respect of Wales, it would assist in Module 1, which of course is looking at the system for communication between the United Kingdom Government and the devolved administrations, to see how communication actually then unfolded in Module 2. So, in summary, we ask that these communications are disclosed, if they've not already been disclosed, as a matter of urgency. Briefly on expert witnesses, we note that for Module 1, many of the expert reports were in draft when the evidence proposals were circulated by the inquiry. This naturally created difficulties for core participants, not knowing what the final expert report would say. Therefore, in Module 2, we ask you to introduce a deadline for the service of final expert reports to ensure that they are then served in advance of your CTI's evidence proposals. As to the substance of the draft expert reports, we once again do raise a concern at the level of detail and analysis in these reports in relation to Wales. As you know, we've raised concerns about the lack of specificity and the limited comparison between the devolved nations, and frequently a distinct lack of analysis of the communication and interaction between the devolved governments and the UK government. We obviously therefore look forward to receiving the finalised expert reports, which we very much hope will contain more analysis in relation to the issues that I've just highlighted. Finally, my lady, the Covid-19 bereaved Families for Justice Cymru once again offer their continued support to the commemoration and to Every Story Matters, and they wish to make clear to you today that they will continue to work with your team in developing your understanding of the experience of the bereaved families of Wales. Thank you very much.
Thank you very much indeed, Ms Heaven. I'm very grateful for your office of support as well. Right, could we return please at 2:15?